I was 34 years old when I learned that the most dangerous person in a courtroom isn't always the defendant. Sometimes it's the person wearing the black robe. My name is Rebecca Martinez, and I'm about to tell you how I brought down Judge Harold Wittmann, a man who'd spent 15 years destroying lives from behind his mahogany bench. What started as a routine divorce hearing became the biggest corruption scandal our county had seen in decades. You might want to grab some coffee, because this story has more twists than a mountain highway, and trust me, you'll want to stay for what happens next. It began on a Tuesday morning in October. I'd been practicing family law for 8 years, long enough to know that divorce cases could get messy, but not long enough to recognize the warning signs of judicial corruption staring me straight in the face. My client, Diana Chen, sat beside me, clutching a folder of financial documents that told a story no woman should have to live. Her husband, a prominent local businessman, had hidden assets worth nearly $2 million while claiming poverty in their divorce proceedings. I'd done my homework. Bank statements, property records, business filings. Everything was there, black and white, irrefutable. Diana deserved half of everything they'd built together over 23 years of marriage. I should have known something was wrong when Judge Wittmann barely glanced at the evidence I'd spent 3 weeks compiling. His weathered face remained impassive as I presented bank records showing her husband's undisclosed accounts in the Cayman Islands. He didn't even look up when I showed him the deed to a vacation property in Aspen that somehow hadn't appeared on any disclosure forms. "Counselor Martinez," he interrupted, his voice carrying that particular brand of authority that comes from decades of never being questioned. "These allegations are serious, but I'm not seeing sufficient proof of intentional concealment." I blinked. Had he even looked at the documents? "Your Honor, if you'll examine Exhibit 14, you'll see wire transfers totaling." "I've seen enough." His gavel came down with a finality that made my stomach drop. "The court finds no evidence of hidden assets. The divorce will proceed based on the financial disclosures already submitted." Diana's sharp intake of breath beside me was the only sound in the courtroom. 23 years of marriage, reduced to the crumbs her husband had deigned to acknowledge. I watched her shoulders shake as the reality settled in. She'd get maybe $30,000 and the mortgage on their family home. He'd walk away with millions she'd helped him earn, free to start fresh with his 25-year-old secretary. That night, I called my mentor, Elizabeth Torres, a retired judge who taught me everything I knew about reading between the lines in legal proceedings. She listened quietly as I described the hearing, and when I finished, she was silent for so long I thought we'd been disconnected. "Becca," she finally said, her voice heavy with something I couldn't identify, "how well do you know Harold Wittmann's history?" "He's been on the bench for 15 years, appointed by Governor Morrison." "Why?" Another pause. "Meet me for coffee tomorrow. There are things you need to know." The next morning, Elizabeth slid a manila folder across the table at our usual cafe. The folder was thin, but heavy with implication. "Harold Wittmann wasn't always a judge," she began, stirring her coffee methodically. 30 years ago, he was a family law attorney. A very successful one. Inside were newspaper clippings from the 1990s, yellowed with age but still legible. He'd represented wealthy husbands almost exclusively, built his entire practice on helping rich men hide assets from their wives during divorce proceedings. "But that's not the interesting part," Elizabeth continued. "The interesting part is what happened in 1994. A woman named Patricia Newman accused Wittmann of bribing court officials to seal financial records in her divorce case. She claimed her husband paid Wittmann an extra $100,000 to make sure she never saw a dime of their shared business ventures." I looked up from the clippings. "What happened to her case?" "It disappeared. Files went missing. Witnesses recanted their statements. Patricia Newman moved to Oregon and never spoke about it again. The pieces were starting to form a picture I didn't want to see. And 5 years later, Wittmann gets appointed to the bench by a governor whose campaign received significant contributions from several of Wittmann's former clients," Elizabeth added, "including Diana's husband, by the way. Richard Chen donated $50,000 to Morrison's re-election campaign just 2 months before Wittmann's appointment was announced." The coffee suddenly tasted bitter. Are you saying what I think you're saying? I'm not saying anything. But if I were you, I'd start paying very close attention to Judge Wittmann's decisions in high-asset divorce cases. Patterns have a way of revealing themselves. I spent the next 2 weeks doing exactly that. Court records are public information, and I'd learned long ago that the devil lives in the details. What I found made me wish I'd never opened that first file. Over the past 5 years, Judge Wittmann had presided over 47 high-asset divorce cases. In 43 of those cases, he'd ruled in favor of the higher-earning spouse, typically the husband. The pattern was so consistent, it would have been statistically impossible if the decisions were actually based on evidence and law. One name kept appearing in these favorable cases: Mitchell Brennan, a high-powered attorney who specialized in representing wealthy individuals in family court. I started keeping a spreadsheet. Case names, dates, attorneys involved, outcomes. The pattern became undeniable. When Mitchell Brennan represented a client before Judge Wittmann, his client won 93% of the time. When the same attorney appeared before other judges in the county, his success rate dropped to 68%. Still good, but not impossibly perfect. The math was simple, but proving corruption required more than statistics. I needed evidence of the actual exchange of money or favors. I needed to catch them in the act. That's where my investigator friend, Jamie Rodriguez, came in. Jamie had worked private investigation for 12 years before starting her own firm, and she specialized in financial crimes. More importantly, she'd grown up poor and had zero tolerance for wealthy people who tried to cheat their way out of paying what they owed. "You realize what you're asking me to do," she said after I'd explained my theory about Wittmann and Brennan. "You want me to investigate a sitting judge. The kind of investigation that could end both our careers if we're wrong. And if we're right? If we're right, we're going to need bulletproof evidence. The kind that would convince a federal prosecutor to risk their reputation on a corruption case." Jamie agreed to help, but she insisted we start small and work our way up. We began by following the money in cases where the outcome seemed most suspicious. What we found wasn't a smoking gun, but it was a trail of breadcrumbs that led somewhere dark. Judge Wittmann had purchased a vacation home in Florida 18 months earlier, paying cash for a property worth $400,000. His official financial disclosure listed his salary and standard investments, nothing that would account for that kind of liquid cash. More interesting were the timing of certain property transactions. 3 months before Diana's hearing, Richard Chen had sold a piece of commercial real estate to a company called Coastal Holdings, LLC. The sale price was below market value, which seemed odd for a supposedly cash-strapped businessman. Coastal Holdings, it turned out, was owned by a trust, and the trustee was Judge Wittmann's brother-in-law. "It's not illegal," Jamie explained as we sat in her office reviewing the documents, "but it's suspicious as hell. Chen sells property cheap to a company connected to the judge, then gets a favorable ruling that saves him millions in divorce settlement. We found 4 similar transactions over the past 2 years. Each time, a wealthy spouse involved in a high-asset divorce had some kind of business dealing with companies connected to Judge Wittmann or his family. Each time, that same spouse had received an unusually favorable ruling in their divorce case. The amounts weren't huge, $50,000 here, $75,000 there, but they added up to a clear system of quid pro quo. Here's what I think is happening," Jamie said, spreading the documents across her conference table like a puzzle we were finally solving. "Brennan identifies clients who have the most to lose in divorce settlements. He approaches them with a solution. Make certain property transactions or business deals, and their divorce will go much more smoothly than expected. And Wittmann gets his cut through these below-market property deals." Exactly. It's not as crude as stuffing cash in an envelope, but the result is the same. Wealthy husbands pay money, Judge Wittmann gets richer, and their wives get screwed. Our break came 3 weeks later, when Robert Kingston filed for divorce from his wife of 19 years. Kingston owned a chain of successful restaurants and had estimated assets worth over $3 million. His wife, Jessica, had been a stay-at-home mother who'd raised their 2 children while he built his business empire. Robert Kingston hired Mitchell Brennan 2 days after the divorce papers were served. Jamie started surveillance immediately. What she discovered over the next month was better than anything we'd hoped for. Brennan didn't just represent his clients. He provided them with a comprehensive service package that included financial restructuring, asset protection, and what he euphemistically called judicial relations management. The key was a private golf club called Riverside Country Club, where Judge Wittmann was a longtime member. Brennan would arrange for his clients to join the club, ostensibly for legitimate business networking. But the real purpose was to create opportunities for informal contact with the judge outside the courtroom. Jamie documented 3 separate occasions when Robert Kingston, Mitchell Brennan, and Judge Wittmann played golf together at Riverside. She couldn't record their conversations, but she photographed them together, and more importantly, she tracked the timing of those golf games. Each one preceded a significant development in Kingston's divorce case. After their first golf game, Judge Wittmann granted Brennan's motion to seal certain financial records. After the second, he denied Jessica Kingston's request for temporary alimony, despite clear evidence that she needed financial support. After the third golf game, Kingston suddenly transferred ownership of 2 restaurant locations to a newly formed LLC, managed by a company that turned out to be connected to Judge Wittmann's investment portfolio. "This is it," Jamie said, showing me photographs of the 3 men shaking hands on the 18th green. "This is how they do it. Golf games, business deals, and judicial rulings, all coordinated like clockwork." The proof came from an unexpected source: Robert Kingston himself. Jessica Kingston had hired a different attorney, someone who didn't understand the system she was fighting against. Her lawyer, David Park, was young and idealistic, and actually believed that evidence and law mattered in family court. When Judge Wittmann dismissed crucial financial evidence in a preliminary hearing, David made the mistake of filing a motion for recusal, citing possible judicial bias. The motion was denied, of course, but it rattled Kingston enough that he made a crucial error. He called Mitchell Brennan from his personal cell phone and had a conversation that lasted 37 minutes. The call happened to take place while Kingston was at his flagship restaurant, which had recently installed a new security system with audio recording capabilities. Restaurant security systems aren't designed to capture phone conversations, but when someone is shouting angrily into their phone in a supposedly soundproof office, technology sometimes picks up more than intended. Jamie had cultivated a contact among the restaurant's IT staff, a young woman named Carol, who'd grown suspicious of her boss's behavior during the divorce proceedings. When she realized that the restaurant's security system might have inadvertently recorded Kingston's phone conversation, she made a copy of the audio file before it could be automatically deleted. The recording quality was poor, but the content was explosive. Kingston was furious about something David Park had filed in court, and he wanted Brennan to make sure Judge Wittmann understood the situation. The exact words were hard to make out, but certain phrases came through clearly. "I've paid good money for this arrangement," and quote, "that judge better remember who his friends are," and most damning of all, "the golf club membership fees alone should buy me more loyalty than this." The recording was legally problematic. It had been obtained without Kingston's knowledge, which made it inadmissible in court under normal circumstances. But it wasn't meant for court, it was meant for the FBI. Federal corruption investigations operate under different rules than civil litigation, and evidence of ongoing criminal activity can sometimes be used to obtain warrants for more extensive surveillance. Jamie had a contact at the Bureau, a white-collar crime specialist named Agent Sarah Thompson, who'd built her career prosecuting corruption cases. Thompson listened to our evidence with the kind of professional skepticism I'd learned to expect from federal investigators. She asked detailed questions about our methods, our timeline, and our motivations. She was particularly interested in the financial transactions we'd uncovered. "Judicial corruption is notoriously difficult to prosecute," she explained during our second meeting. "Judges have enormous discretionary authority, which means that bad decisions aren't necessarily criminal decisions. We need to prove explicit quid pro quo, money or value exchanged for specific judicial actions." That someone turned out to be Mitchell Brennan's former law partner, a man named Gregory Walsh, who'd left the firm 6 months earlier, under circumstances that everyone involved preferred not to discuss publicly. Jamie tracked Walsh down at his new practice in a different county, where he was slowly rebuilding his career handling workers, compensation cases, and personal injury claims. Walsh was initially reluctant to discuss his former partnership with Brennan, but when Jamie mentioned Judge Wittmann's name, his demeanor changed completely. I wondered when someone would finally start asking questions, he said, pouring himself 3 fingers of bourbon even though it was barely past noon. I tried to pretend it wasn't happening. Tried to tell myself that Mitch was just really good at reading judges, really good at presenting cases in ways that resonated with their judicial philosophy. Walsh had kept meticulous records, partly out of professional habit and partly out of a growing sense that he might someday need to protect himself. His files documented a systematic operation that was far more sophisticated than we'd realized. Brennan didn't just arrange golf games and property deals. He'd created an entire ecosystem of corruption that involved multiple businesses, several attorneys, and a network of financial relationships designed to obscure the flow of money from wealthy divorce clients to Judge Wittmann. Clients didn't simply pay bribes to Judge Wittmann. Instead, they entered into a complex web of financial relationships that provided the judge with ongoing benefits while maintaining enough legal separation to make prosecution difficult. The golf club memberships were just the beginning. Wealthy clients also invested in a private equity fund that Judge Wittmann helped manage through a family trust. They purchased insurance policies from a company owned by the judge's brother-in-law. They hired a consulting firm owned by Wittmann's wife to provide business advisory services that consisted mainly of rubber-stamping decisions they'd already made. Each transaction was legal in isolation, Walsh explained. But taken together, they created a system where Judge Wittmann benefited financially every time he ruled in favor of one of Brennan's clients. And the amounts were significant, probably $200,000 or $300,000 a year in additional income. Walsh agreed to cooperate with Agent Thompson's investigation, but he warned us that Brennan and Wittmann had probably suspected for months that someone was looking into their arrangement. Mitch is paranoid by nature, and judges hear everything that happens in the legal community. They know someone's been asking questions. Agent Thompson confirmed Walsh's concerns when we met with her the following week. The FBI had opened a preliminary investigation based on our evidence, but federal corruption cases moved slowly, and they needed more than circumstantial evidence to obtain the kind of surveillance warrants that might catch Wittmann and Brennan in explicit criminal activity. We're looking at a minimum of 6 months before we could bring charges, assuming we can develop additional evidence, Thompson explained. And that's if everything goes perfectly. But justice delayed is justice denied, and I couldn't stand by and watch more women get destroyed while we waited for federal investigators to build their perfect case. That's when I made a decision that probably saved several lives but nearly ended my career. I decided to go public. The local newspaper, the Metropolitan Herald, had an investigative reporter named Tom Bradley who'd built a reputation for exposing corruption in county government. I called Bradley and asked if he'd be interested in a story about judicial corruption. We met at a coffee shop in the next county over, far from the courthouse where Judge Wittmann might have allies who could report back on unusual meetings. Bradley listened to my story with the kind of focused attention that told me he understood the significance of what I was describing. "This is explosive material," he said after I'd finished explaining our investigation. "But it's also incredibly dangerous to publish without absolute certainty. Judges can destroy newspapers with defamation lawsuits." It was a fair concern. Attorneys who lose cases sometimes develop elaborate theories about judicial bias to explain their failures. But our evidence went far beyond sour grapes, and Bradley was professional enough to recognize that after he'd spent 2 weeks reviewing our documentation. "I've looked at 43 different cases," he told me during our final meeting before publication. "The pattern is undeniable. Judge Wittmann's rulings in high-asset divorce cases are statistically impossible to explain through normal judicial variation." The story broke on a Friday morning when the Herald's editor decided that news this significant couldn't wait for the Sunday edition. By 10 a.m., every attorney in the county had read the headline, "Local Judge Accused of Systematic Corruption in Divorce Cases." By noon, Judge Wittmann had issued a statement denying all allegations and threatening to sue the newspaper for defamation. By evening, the State Judicial Ethics Board had announced a formal investigation. My phone started ringing at 6 a.m. and didn't stop for the next 3 days. Other attorneys wanted to know if their cases had been affected. Reporters wanted additional details. Former clients of Mitchell Brennan wanted to know if they could reopen their divorce settlements. And Judge Wittmann's allies wanted to know who I thought I was, to question the integrity of a respected member of the judiciary. The personal attacks started almost immediately. Someone leaked information about my student loans and my modest salary to suggest I was motivated by financial desperation. Anonymous letters appeared in the newspaper suggesting I was an incompetent attorney looking for excuses to explain my courtroom failures. Someone started a rumor that I was having an affair with the newspaper reporter, implying that the corruption story was somehow the result of pillow talk rather than legitimate investigation. But the attacks also proved that we'd hit our target. Innocent judges don't mobilize character assassination campaigns against their critics. Honest public officials don't need armies of supporters to explain away evidence of wrongdoing. The fact that Judge Wittmann was fighting so hard to discredit me told everyone paying attention that our accusations had merit. The real vindication came 2 weeks after the story broke, when Agent Thompson called to tell me that the FBI investigation had been accelerated based on new evidence that had emerged following the newspaper coverage. 3 more attorneys have come forward with information about suspicious rulings, she explained. And we've received documentation of financial transactions that we hadn't previously identified. Your decision to go public has opened floodgates. More importantly, several women who'd been victimized by Wittmann's corrupt rulings had contacted the FBI with additional evidence of the systematic nature of the conspiracy. They'd been afraid to speak out before, worried that challenging a powerful judge would only make their situations worse. But once the story became public, they realized they weren't alone. Most damaging of all was testimony from a former secretary at Mitchell Brennan's law firm, a woman named Patricia, who'd been laid off 6 months earlier in what she now realized had been an effort to eliminate potential witnesses. Patricia had kept copies of financial records that documented the systematic nature of the corruption scheme, including spreadsheets that tracked which clients had made payments to Judge Wittmann's various business interests, and how those payments correlated with favorable rulings. They kept records of everything. Agent Thompson told me during one of our regular briefings, Brennan's firm treated judicial corruption like any other business process, tracked expenses, measured return on investment, maintained customer relationship databases. It's the most thoroughly documented bribery scheme I've ever investigated. The evidence was so overwhelming that Judge Wittmann's situation became untenable within a month of the initial newspaper story. The State Judicial Ethics Board suspended him pending their investigation, which meant he could no longer hear cases while the federal criminal investigation proceeded. Mitchell Brennan's law firm was raided by FBI agents who seized computers, financial records, and filing cabinets full of documents related to the corruption scheme. But the most satisfying moment came when Robert Kingston, the restaurant owner whose recorded phone conversation had provided crucial evidence, was arrested on federal conspiracy charges. His arrest made national news because of its connection to the broader judicial corruption case. And suddenly, everyone in our legal community understood that this wasn't just about one corrupt judge. It was about a systematic effort to subvert the entire family court system. Federal prosecutors ultimately charged Judge Wittmann with 15 counts of conspiracy, bribery, and honest services fraud. Mitchell Brennan faced similar charges, along with additional counts related to money laundering and tax evasion. The indictment described a, quote, systematic scheme to corrupt the judicial process that had operated for at least 5 years and had affected dozens of families throughout our county. The trial lasted 3 months and attracted national media attention as an example of how corruption could infect even the most trusted institutions in American society. Gregory Walsh, the former law partner who'd provided crucial evidence, testified for the prosecution under a cooperation agreement that reduced his potential sentence in exchange for his assistance in exposing the conspiracy. The evidence presented during the trial painted a picture of breathtaking greed and callousness. Judge Wittmann had received over $400,000 in payments disguised as legitimate business transactions, while dozens of women had been cheated out of millions of dollars in marital assets they were legally entitled to receive. The jury deliberated for less than 8 hours before returning guilty verdicts on all charges. Judge Wittmann was sentenced to 12 years in federal prison, while Mitchell Brennan received 10 years. Both men were also ordered to pay restitution to their victims, though the amounts involved were so large that full compensation would be impossible. But the real victory wasn't the criminal convictions. It was the systematic reform that followed. The state legislature passed new laws requiring financial disclosure for all judicial candidates and mandating recusal in cases where judges had any business relationship with the parties involved. The State Bar Association implemented new ethics training requirements for attorneys, with specific focus on recognizing and reporting judicial corruption. Most importantly, victims of the corruption scheme were given new legal remedies to challenge the fraudulent court orders that had cheated them out of their rightful assets. Diana Chen was able to reopen her divorce case and ultimately received a settlement worth over $800,000. Not full justice, but enough to rebuild her life with dignity. In total, 17 women were able to recover assets that had been stolen from them through judicial corruption, representing over $12 million in corrected settlements. The personal cost of exposing the corruption was significant, but manageable. Several prominent attorneys stopped referring cases to me, apparently concerned that association with someone who'd attacked the judiciary might harm their own standing in the legal community. I received threatening letters and hostile phone calls for months after the story broke. Someone vandalized my car and threw a brick through my office window. But I also received letters of support from dozens of women who'd been victimized by corrupt family court decisions, and my practice ultimately grew stronger as word spread that I was willing to fight for my clients regardless of the personal consequences. More importantly, I learned that individual actions could still matter in a system that often seemed designed to protect the powerful at the expense of everyone else. One person with documentation and determination could expose corruption that had operated in plain sight for years. One attorney with a willingness to risk her reputation could give voice to victims who'd been silenced by shame and intimidation. One newspaper story could trigger investigations that brought down a criminal conspiracy involving some of the most powerful people in our community. The experience taught me that corruption thrives in darkness but withers under scrutiny. Judge Wittmann and Mitchell Brennan had been able to operate their scheme for years because no one had bothered to look closely at the patterns in their behavior. Once those patterns became public, the entire conspiracy collapsed within months. Today, Judge Wittmann is serving his sentence at a federal prison in Kentucky, where he'll remain until 2037. Mitchell Brennan is incarcerated in Georgia, scheduled for release in 2035. Both men lost their law licenses, their reputations, and their freedom because they forgot that public service requires actual service to the public rather than exploitation of public trust for private gain. I still practice family law, though I'm more selective about cases now and more aware of the warning signs that might indicate judicial corruption. I speak regularly at continuing education seminars about recognizing and reporting judicial misconduct, sharing the lessons I learned from an experience that nearly destroyed my career but ultimately strengthened my commitment to justice. The corruption investigation also led to my meeting James Morrison, whose sister had been victimized by Judge Wittmann's corrupt rulings. James had been following his sister's divorce case and had suspected that something was wrong with the judge's rulings long before our investigation began. James and I began working together on cases involving complex financial analysis, and our professional partnership eventually developed into something more personal. We were married 2 years after Judge Wittmann's conviction, in a small ceremony attended by many of the women whose lives had been changed by our investigation. The wedding was a celebration not just of love, but of the community that had formed around our shared experience of challenging corruption and demanding accountability. These women had supported each other through the investigation, the trial, and the long process of rebuilding their lives after being victimized by people they'd trusted to protect them. They'd learned that justice wasn't automatic, but that it was possible when people were willing to fight for it. Looking back on the experience 5 years later, I'm struck by how much changed because one person was willing to pay attention to patterns that everyone else had ignored. Judge Wittmann's corruption had been hiding in plain sight, documented in public records that anyone could have accessed. The evidence was there, waiting for someone to connect the dots and ask the right questions. The real tragedy wasn't just the money that was stolen or the lives that were damaged. It was the years of suffering that could have been prevented if someone had spoken up sooner. The investigation also revealed the broader systemic problems that make judicial corruption possible in the first place. Family court operates with less oversight than almost any other part of the judicial system, partly because the cases involve private family matters that the public rarely pays attention to. Judges have enormous discretionary authority in dividing assets and determining custody, which makes it difficult to distinguish between legitimate judicial decision-making and corrupt favoritism. Most importantly, the victims of family court corruption are often women who are already vulnerable because of divorce proceedings, financial dependence, and social isolation. They're easy targets for corrupt officials because they lack the resources and connections needed to challenge powerful judges and attorneys. The system counts on their silence, their shame, and their inability to fight back effectively. But our investigation proved that silence isn't inevitable. When victims find their voices in support of allies, even the most entrenched corruption can be exposed and defeated. The key is creating networks of accountability that bridge the gaps between individual cases and systematic patterns of abuse. Today, I serve on a state committee that monitors judicial conduct and reviews complaints about potential corruption. We've implemented new systems for tracking patterns in judicial decision-making, using statistical analysis to identify cases where outcomes seem inconsistent with evidence and legal precedent. It's not a perfect system, but it creates additional layers of scrutiny that make corruption more difficult to sustain. I also work with a nonprofit organization that provides legal assistance to women who suspect they've been victimized by judicial corruption. We help them gather evidence, connect with investigators, and navigate the complex process of challenging fraudulent court orders. The organization was founded by one of the victims, who used part of her recovered divorce settlement to create resources that hadn't existed when she needed them. The experience of exposing Judge Wittmann's corruption taught me that individual courage can create systemic change, but only when it's supported by institutional accountability and community solidarity. One person speaking out isn't enough. It takes networks of allies, professional investigators, responsible journalists, and committed prosecutors working together to challenge entrenched corruption effectively. It also taught me that justice isn't a destination, but an ongoing process that requires constant vigilance and active participation. Corrupt officials count on public apathy and professional complacency to protect their schemes. They assume that ordinary people won't pay attention to complex financial transactions or subtle patterns of bias in judicial decision-making. But ordinary people can learn to recognize corruption when they know what to look for, and they can demand accountability when they understand how systems are supposed to work. The women who were victimized by Judge Wittmann's corruption weren't legal experts, but they knew injustice when they experienced it. They just needed someone to listen to their concerns and take their experiences seriously. 5 years after Judge Wittmann's conviction, family court in our county operates very differently than it did during his tenure. Judges are more careful about documenting their reasoning for decisions involving asset division. Attorneys are more aware of the warning signs that might indicate judicial bias or corruption. Court administrators have implemented new procedures for tracking patterns in judicial decision-making and investigating complaints about potential misconduct. The changes aren't perfect, and corruption probably still exists in ways we haven't yet learned to recognize. But the system is more transparent, more accountable, and more responsive to the needs of people who depend on family court for justice in the most difficult moments of their lives. The story of Judge Wittmann's corruption is ultimately a story about the power of ordinary people to challenge extraordinary abuses of authority. It's about the importance of paying attention to patterns that others ignore, asking questions that make powerful people uncomfortable, and refusing to accept injustice as inevitable. Most importantly, it's a story about the possibility of justice in a system that often seems designed to protect the powerful at the expense of everyone else. Judge Wittmann believed he was untouchable because he'd spent years manipulating the system without consequences. Mitchell Brennan thought his wealth and connections would shield him from accountability. Both men discovered that no one is above the law when communities organize to demand justice. Today, when I meet with new clients who've been victimized by family court decisions that seem unjust or inexplicable, I listen carefully to their stories and look for patterns that might indicate corruption or bias. I ask detailed questions about the judge's behavior, the opposing attorney's tactics, and the financial relationships that might exist beneath the surface of their cases. Sometimes those cases are simply the result of bad luck or incompetent representation. But sometimes they reveal systematic problems that require systematic solutions. And when that happens, I remember that one person with evidence and determination can still change the world, especially when that person is supported by a community of allies who refuse to accept injustice as normal. Judge Wittmann is scheduled for release in 2037 when he'll be 78 years old. By then, the women he victimized will have rebuilt their lives, raised their children, and created new systems to protect future generations from the kind of corruption that nearly destroyed them. His legacy will be measured not by the power he once wielded, but by the justice that emerged from his downfall. That's the real lesson of this story. Corruption may be powerful, but it's also fragile. It depends on secrecy, complacency, and isolation to survive. When those conditions change, when patterns become visible, when victims find their voices, when communities organize for accountability, even the most entrenched corruption can be exposed and defeated. The courthouse where Judge Wittmann once presided now has a plaque near the entrance that reads, "Justice is not automatic. It requires the active participation of citizens who refuse to accept injustice as inevitable." The plaque was installed at the request of the women whose cases had been corrupted by his decisions, and it serves as a daily reminder that democracy depends on ordinary people doing extraordinary things to hold their institutions accountable. Every time I walk past that plaque, I'm reminded that the story of Judge Wittmann's corruption isn't really about him at all. It's about all of us and our responsibility to pay attention, speak out, and fight for justice, even when the odds seem impossible and the costs seem too high. It's about the choice between comfortable silence and dangerous truth, between individual safety and collective accountability. It's about the women who refuse to accept that their suffering was inevitable, the allies who refuse to look away from evidence of corruption, and the investigators who refuse to let powerful criminals escape justice. It's about the possibility of change in a world that often seems designed to resist it. And ultimately, it's about the truth that individual actions can still matter in systems that seem too large and too powerful to change. One case, one investigation, one newspaper story, one conviction at a time, ordinary people can still bend the arc of justice toward accountability, even when that arc seems to be bending in the opposite direction. Judge Harold Wittmann thought he could steal from vulnerable women with impunity because he wore a black robe and carried a gavel. He was wrong. And his downfall serves as proof that no one, no matter how powerful they seem, is above the law when communities organize to demand justice. That's a lesson worth remembering, worth sharing, and worth acting on every time we encounter injustice in our own lives and communities. Because justice isn't something that happens to us. It's something we create together. One case at a time, one investigation at a time, one act of courage at a time.